to law and order, the great majority of first home owners or retired persons are opting for an apartment either in a complex or a flat. And when it comes to certain complex, it becomes a bit more complicated when we have both residential and commercial units. So when one is buying an apartment or a complex in a unit, there are different types of ownership. Different ownership with regard to the part of the building. The owner will have full private ownership of the building, which is a home or his home. However, most of the rest of the block or residential complex is owned jointly by all the owners. And this is what we call the common part. Example, the corridors, the parking space, the stairs, etc. The management of this type of building is quite different compared to a simple family dwelling. This is why we need a syndic, where all the co-owners contribute to the common expense of the common part. This syndicate or co-ownership is responsible for all its administrative operation and the common interest of the co-owners. Mr. Deputy Speaker, the question of copropriété has been with us since we inherited the Code Napoleon in 1804. However, since then, there has been various amendments. And in 1950, we have what we call, in the 1950s, we have what we call the Code Civil Mauricien. So today we are dealing with a piece of legislation regarding the syndic. And the last time the law was passed, the law was amended, was in 1983. And this is some of the section of Article 644 was amended. And in 1983, prior to the amendment of the Code Napoleon, there was a select committee. Select committee chaired by the then Attorney General and Minister of Justice, Honorable Shirin Omiroudi Zifa. That committee made his report with regard to various amendments of the Code Civil, Code Napoleon, and it dealt also with the amendment with regard to the code concerning copropriété, syndic. And today, we are amending, coming with a new Article 664. We have heard from the Honorable Attorney General that there has been consultation with most of the stakeholders. But we have not heard from the Attorney General what have been the outcome of this consultation, because my information is, although quite a lot of what was agreed upon is in that bill, but there are many other issues which were raised by the stakeholders which are not in the bill. And there are many important issues where there have been no agreement amongst stakeholders which are not in the bill. Like I said, Mr. Deputy Speaker, in our law today, Article 664 goes to 664 to 94. 664.1, 664.2, go to 664.94. And today, this law, this bill brings Article 664 to 140 subsections with different aliena and each. So I don't propose to go to each and every one, as the Honorable Attorney General said. In some of them, there has been certain amendment, but some are new. Some are new, and some I will ask the Honorable Minister, Honorable Attorney General, for some clarification on certain issues. Let me deal first to the new Article 552. The new Article 552(1), by setting a new Article 552(1), which says un fonds peut faire l'objet d'une division visant à conférer à un tiers la propriété d'une partie de ce fonds située au-dessus ou au-dessous d'une limite conventionnelle fixée. La propriété du est appelée propriété superficielle et celle du dessous, propriété très foncière. This is an article which is copied from the Code Civil, especially the one in Quebec. But there, the Code Civil Quebec, this is a general one. But this Code Civil of Quebec goes even further. It says what happened when at the end of the propriété superficielle. What happened to that property which has been added to the existing property? And there it is well mentioned. La propriété superficielle prend fin par la réunion des qualités de trait foncier et de superficielle dans une même personne, nous réserve toutefois les droits de tiers par l'achèvement d'une condition résolutoire, par l'arrivée à terme. So this is how it ends. But what happened to that property after the expiry of the période limitée conventionnellement fixée? But there in Quebec, it goes further. The owner can either buy the rights, compensate the superficielle, the trait foncière plutôt, enlever les constructions, ouvrages et plantations qu'il a fait et remettre les tréfonds dans son état intérieur. So if they either he removes whatever he has added to the property, or the owner can buy and compensate the other party. However, if there is no agreement between the parties, they can always, Article 118 in the Quebec Code Civil, le trait foncier et le superficiel qui ne s'entendent pas sur le prix et les autres conditions d'acquisition du tréfonds ou de construction, ouvrage ou plantation peuvent demander au tribunal de fixer le prix et les conditions d'acquisition. Le jugement veut titre et en a tous les effets. So here, because why this is important, we are talking about only two people. And we know in Mauritius, especially when it comes between two members of a family, we always have that issue. No, they don't agree with compensation. So I think it should have been better in the code, and the amendment code we are dealing today, to have the procedure to be laid out once the parties or the treaty between the two parties comes to an end. And unfortunately here, there is no mention regarding what will happen after l'expiration du convention. Now let me come to page 10. The Article 664(32). This is quite welcoming because there have been abuse in the past when, let's say that there are 4 buildings in a four flats in a building, and one owns three flats, and one is to a third party. He always control the syndic. So now at least we have his share is reduced to 25%. That is equal to the other partner in that syndic. page 14, which refers to professional. This is interesting that we talk about 664-44. Les fonctions de syndic peuvent être assurées par toute personne physique ou morale, professionnelle ou non, ou bénévole. Here, I have some concern. In many cases, syndic has failed because any person thinks he's qualified to be a syndic. And we know, in age, the Honorable Whip himself asked a question about the qualification of a syndic. If today, in many cases, syndic has failed because we have had a non-professional running the syndic. They are not experienced. And running a syndic is a professional job. It's easy. I know many cases where the gentleman or lady who wants to be a syndic, he just canvass some people. The majority very often don't turn up for the meeting. You get somebody who turned up with a proxy of 15 members and vote for Mr. X. And Mr. X will come for syndic. And unfortunately, he's not a professional. And the other side is also interesting. Most professionals are not interested who own a property in a complex, are not interested to join a syndic. Either they don't have time, either they don't want to be on the bad book of their neighbors or co-owners, because very often it's a delicate job. So I would think that we should have in this law come with a definition of a syndic. I know there's resistance outside. Some people don't want it. But if we want to have buildings, especially flats with hundreds or not hundreds, 25 or 30 flats, or residential complex, including commercial complex on the same building, we should go for professional syndic. And professional syndic, I will come to that later, because in Canada, they just in Quebec especially, they just, in April or June, they just amend the law. A professional syndic will bring transparency, accountability. Today, if you want, if we go in one of these, especially the NHDC one or any syndic, you ask one of the syndic who is, how is it that my share is X rupees? He can't answer. How is it that you come to the figure that I should pay 2,000 rupees per month outside? He can't answer. He hasn't done a calculation. He has done a financial account, according to him. He hires who he wants to hire. Carpenter of his choice, plumber of his choice, painter of his choice. And then he comes with a bill. No accountability. And there is no pressure, unless the Assemblée Générale put pressure. But very often, like I said, the Assemblée Générale is just an assembly with somebody come with 10 or 15 proxy, get majority upset, and they get their way. So I think we should come with something more professional when it comes to syndic, the qualification of a syndic, or somebody to run a syndic. Now let me come to page 2, Article 664, 65 to 63. 63 to 65, sorry. This is interesting, again, for 2 load or 5 load. You don't have to go to a long procedure of all the documents, all the costs involved to install a syndic. But again, everywhere we ask for odd numbers to take a decision. 5, it must be 3. 7, it must be 5. But what it comes to 2? Article 664, 63. It's good that if we have a co-propriety of 2 persons, We don't need a syndic. The two get down together. But it works for a certain time. Unfortunately, many problems arise. You have many houses who are abandoned when two brothers, two sisters, two relatives, they don't get on. So it's good on paper. Whether it will work in practice, this is another issue. Now, I would like some éclaircissement with regard to the code-part. L'article 66467, alinéa 1, 2, 3, 4. Le règlement de copropriété fixé par la quote-part afférente à chaque lot dans chacune des catégories des choses et indique le deuxièmement pris en considération, ainsi que la méthode de calcul ayant permis de fixer le quote-part des parties communes et la réparation des choses. So, your contribution, one is the syndic, le règlement de copropriété, who indicate the method and the way he has reached your quote-part. But what happens if one don't agree? It's his money after all. If he doesn't agree with the calculation, he doesn't agree with the method used. What venue does he have according to the law? Because it says under 66469, you can only change the quote-part, peut-être modifié qu'à l'unanimité des copropriétaires. It's a bit, is that fair? If you get 3-4 persons does not agree, but they are not part of the majority, they have just bought a property, their quote-part has been increased, they don't agree with the way their quote-part has been calculated with the method used. The law does not allow them to do anything. It's only by l'unanimité. That's giving the syndic a lot of power. And to get that unanimity, I ask whether it ever happens. L'unanimité des copropriétaires, not those present. L'unanimité des copropriétaires. So all of them has to be there. Basically, there were 100 buildings. So what happens if some of them are abroad and they have not set a proxy? He's a copropriétaire. So you can't change. And there are many cases, especially in a complex around the beach, where the owners live in England, France, abroad. But it says you can only change it qu'à l'unanimité de copropriétaires. So I would like the Honorable Attorney to tell us why we have gone to that extreme. Why decision is not taken by third majority, or at least unanimity of those present. So a few owners who are outside, living outside the country, can put the syndic to a halt. Now, the other one which is a more concern is Article 66473. Le paiement des créances de toute nature de syndic à l'encontre de chaque copropriétaire existe exigible depuis moins de 5 ans et qu'il s'agit de provisions du paiement défini garanti par une hypothèque légale sur son lot. So now the syndic can have an hypothèque on that plot of land. The law as it is now, you must have a mise en demeure before you hypothèque the land. The syndic can hypothèque the land of a co-owner. Why is it that we are doing away with that service of a mise en demeure? So without his knowledge, without his consent, there is a lien now on his property. And he has never been made aware. No mise en demeure, Mr. Vice. Let me say that mise en demeure. Coming to the law, following the Select Committee of 1983 report, where there was wide consultation with all the stakeholders, they came and deposed. And they found that there was, in order to protect the right of ownership, it was important before you put a mortgage and hypothèque on somebody's plot of land, there should be a hypothèque, there should be a mise en demeure served on the owner, so that he can be made aware and take whatever appropriate action. So I would like the Attorney General again to come and tell us why we are doing away with the service of a mise en demeure on the code. So, Mr. Deputy Speaker, there is today a lack of specific standards regarding the management of coalition. Some scientists do very well, some unfortunately. Even in the LHDC, let's say, there are some scientists who are doing very well, but some, unfortunately, it's just on paper. An obvious lack of knowledge by certain individuals who hold themselves out of managers, and a lack of supervision by co-owners. Even some co-owners today are not aware of their right. Let alone the scientist, he is not qualified. Some, like I say, are doing very well. Some pretend to do. Some are doing nothing. But what about the owners? Most of the owners, especially in the LHDC, they are not even aware of their rights as a co-owner. Some don't even know who is responsible for the science in some cases. So this is why I say we should have professionals to run the science. There should be a minimum qualification required. Because experience has shown, Mr. Deputy Speaker, in the maintenance of certain buildings and the transparency of information available to co-owners, unfortunately, most of the scientists do not open their books. Many people are not aware, doesn't know how their money are being spent. But I will conclude by referring to an article which is what they are doing in Quebec, dated June 2018. So in addition to amending their constitution, if there's one person who is supposed to be independent to know the state of the flat, because just by a painting we don't know what there is behind. We need the state of the flat. They are putting it in the law. The syndic is responsible to have an up-to-date report, not only of the financing of the syndic, but also on the state of the building they are dealing with. Now we found the last one which I intend to raise is the question of copropriété en difficulté. Article 664/108. This mentions that a syndic who is in financial problem can prepare a brief of financement and receive money from the state ou de la collectivité locale sur le territoire de laquelle est situé l'immeuble qui est chargé de l'administrer. This is you. So a syndic who is in financial difficulty can approach government for money and approach the local authority. I would like the Honorable Attorney General or somebody who will intervene after me to tell us how this will be done. Who is going to contribute to that syndic? Taxpayers' money. We are talking of ratepayers and taxpayers' money who will go to that syndic. What transparency there will be? Is that money will come back in the kitty of the local or national government? How this will be done? It sounds interesting on paper. Okay, we'll finance your syndic. But how? Where does the money come from? Who is going, where will the money go back to government after the syndic has stabilized its financial situation? So these are issues which I will like the Honorable Minister to enlighten us. Like I say, there are many new Section 2, Article 664, which have been added. And it's only time which will tell us whether they will remain only in our textbook. So now some textbook, they are practical, how it will work. It's only time, especially when it comes to to the cities, smart cities, or big complex we are doing. So only time will tell us whether it is working or not. But there are, like I say, good intention, but there is a lot of clarification that, and I hope the summing up will enlighten us, especially the article Chairman mentioned. I'm done, Mr. Deputy Speaker.